There are really a million things I want to say, and I kind of don't exactly know how to begin. I wrote out a week or so ago a learned statement about stare decisis that would be fascinating to scholars for the evening. And I'll summarize it later on, but as the day has gone on, I thought it might be more appropriate to talk a little bit about the Chicago Cubs. You know, I got a jacket that will keep me warm on cold days earlier today, and I'm very happy to have it. But it occurred to me that there are 5 dates in which the Chicago Cubs had a significant impact on my life. And I thought I'd mention each one of those dates today. The first was in October of 1929. I had been a fan at age 9 of the Cubs for quite a long time at that time, because the Cubs were broadcast on 3 different radio networks, the WMAQ, WBBM, and WGN, and I had listened to every game for 2 summers, I think. I knew the lineups, the batting averages, everything about the Cubs. And in 1929, some of you may have read, you may not remember, the Cubs were in the World Series. And in October, my dad took me to the first ball game that I ever was privileged to attend. And he got seats right behind home plate where you could really watch the pitches come over the plate. And I was really looking forward to one of the greatest days in my life, because the Cubs had hitters like Hack Wilson, Gabby Hartnett, Charlie Grimm, Riggs Stevenson, Kai Kyler. They had a really wonderful batting team. I think that was the year that Hack Wilson hit 54 home runs. I may be off a year or 2. But in any event, I was looking forward to not only my first ball game, my first World Series, but to see my heroes really perform. And what happened? Connie Mack, instead of starting either Lefty Grove or George Earnshaw, who were probably the 2 of the greatest pitchers in the league at the time, he put in a has-been named Howard Emke, I think his name was. He was a relief hurler who was on his last days on the bench. He could hardly throw the ball to the plate. And what did he do? He struck out 13 of my heroes. You never forget a day like that. They lost that game, and of course they lost the series as well. Then in 1932, the event that probably I will be most remembered for occurred. I was in the ballpark when Babe Ruth called his shot after responding to razzing from Guy Bush in the dugout and otherwise. He went out. This was his 2nd home run on that day, as I'm sure many of you know you don't remember, but that's true. And I can testify and have testified on more than one occasion that he did indeed point to the center field scoreboard and hit a home run over in center field. But that's common knowledge. In 1951, I was the associate counsel to the House Judiciary Committee, the subcommittee on monopoly power of the House Judiciary Committee, and we investigated organized baseball. And one of the witnesses in that investigation was P.K. Wrigley. And I had the privilege of cross-examining P.K. Wrigley at some length. And yesterday I took a look at the brilliant cross-examination that I conducted. And the fact that I really brought out, which was terribly important, is that they did not have lights, whereas every other team in the league did. And that may not seem significant to you, but in fact, it had much significance in the next chapter that I want to tell you about, which occurred in 1969. As some of you may know, I was counsel for the commission that was jointly formed by the president of the Illinois and Chicago Bar Associations to investigate the integrity of the judgment in People against Isaacs. And there are many people who think that investigation is what brought me into the public eye, which led to my appointment to the Court of Appeals and eventually to the Supreme Court. So my appointment, I might say though that Bill Barnhart has a book out that has a different version of the facts. You may be interested in reason. He doesn't think that it was that direct proximate cause. But for purposes of this story, we will assume that my work on that investigation is why I had a job in Washington for 35 years. And the fact of the matter is that I was the second choice of the commission to be the general counsel. The first choice was Milt Shader, who had a brilliant record at the University of Chicago and has been a distinguished judge here for many, many years, as you know. But the problem was that he had brought a lawsuit. At least Ed Austin, who was on the 5-member commission, understood that he was behind the lawsuit that by a minority shareholder of the Cubs saying the failure to have lights was a basis for a lawsuit against the Cubs. And the counsel for the Cubs was on the commission, and he did not want Milt Shader to be the general counsel, so they took their second choice. And I was second choice, so what it really means to, when you sort it all out carefully, is that the Cubs' failure to have lights is why I went to the Supreme Court. But then the fifth important event, and this perhaps is even more significant than any of those four, is Ann has already referred to this. I was invited to throw the first pitch out at the game against Cincinnati back in, I think it was 2005. And Ann is dead right. She's told the guts of my story. When I first tried to throw the ball, and I used to be able to play pretty good baseball, it went about halfway to the plate, and I did exactly what she said. And I pretended I was in the outfield trying to get somebody out at the plate and threw it as though it was that kind of a pitch, and it was high and outside. It was a good throw. But the reason that was so significant is that a lot of my grandchildren were in the stands at the time. And I can tell you that that is much more important than than being a member of some court down in Washington today. So I was really a hero on that day. That was the big day. Now I'm not going to read what I've written out, but I think since I took the time to put the thoughts together, I'll give you a brief summary of what I was going to say. And what I do, I point out that the Supreme Court, without being asked to do so, overruled an opinion that I had written about 15 years earlier. And then I surprise you by saying, no, it's not Citizens United, it's a case involving confessions. And in that overruling opinion, Justice Scalia gave 4 reasons why you should determine whether or not stare decisis should interfere with the reconsideration of a settled precedent. And I go through each of his 4 reasons, and I suggest that the first 3 clearly would justify overruling the Second Amendment case, the Heller case involving the Second Amendment right to bear arms. And then the 4th of his reasons goes to whether or not the opinion was well reasoned. And I say a few words about the reasoning in the Heller case, which some of you may know I did not join, to put it mildly. And I must say, in working on my dissent in the case, I had immense help from the daughter of our presiding officer today, Kay Shaw, who is with us today. But I'll just read some of what I wrote about that. I said, over the years, guns have been used for military purposes, for hunting, for self-defense, for criminal activities, and occasionally to fight duels. And in the United States against Miller, decided back in 1939, the court held that Congress could prohibit the possession of weapons that have no reasonable relation to the preservation or efficiency of a well-regulated militia. And when I joined the court in 1975, that holding was generally understood as limiting the scope of the Second Amendment to uses related to military activities. But then 2 years ago, in Heller, the court concluded that the amendment also protects the use of guns for self-defense, at least in the home. I remain persuaded that that conclusion is wrong. And then I get into talking a little bit about the reasoning in the opinion, and I get to this point. I saved you about 7 pages. Save you 2 more. I'll just kind of get in the middle, and I think you'll pick up with what I had in mind. As I'm sure you all remember, in his colloquy with Alice after he passed through the looking glass, Humpty Dumpty used a rather scornful tone to tell her that when I use a word, it means just what I choose it to mean, nothing more, neither more nor less. In Justice Scalia's discussion of the words of the Second Amendment in his Heller opinion, he did not use a scornful tone, but I think that Humpty Dumpty would have endorsed his textual analysis. The text as that amendment is very brief. It says, "A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed." As Justice Scalia explains toward the end of his opinion, the right secured by that amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever and for whatever purpose. I, of course, agree with that portion of his opinion. I think the court in 1939, in the Miller case I mentioned earlier, had correctly read the brief text that I have quoted and the relevant history to identify a right that is limited to the militia-related purposes. Under Justice Scalia's view, however, that right is apparently not one that is limited by the text of the amendment that defines it. In my view, this position, that the scope of the amendment the scope of the Second Amendment is broader than its text, is possible only if one uses a Humpty Dumpty-like 3-step approach to the text of the key phrase, "to keep and bear arms." First, tell us what those words mean before examining the preamble that identifies the purpose of the provision. Second, treat the single phrase in the text as though it were 2 phrases, keep arms and bear arms. And then, in step 3, scour founding era sources for examples using each of those components of the text in idiomatic ways devoid of their normal, natural military meanings. Only after thus putting the text through the looking glass can one find that it guarantees, quote, the individual right to possess and carry weapons in cases of confrontation, unquote, which is what the court has said it meant. Having defined the meaning of the operative clause of the amendment, one then turns at last to what comes first, the preamble, to see if it comports with that definition. To conclude that it does, one must again mimic Humpty Dumpty, now by construing the words of the preamble, quote, a well-regulated militia being necessary to the security of a free state, unquote, to mean, quote, an unregulated individual's possession of a handgun being necessary for his self-defense, unquote. The result would make Humpty Dumpty proud, though the actual operative clause provides that the right of people to keep and bear arms shall not be infringed. Its meaning has been transformed into something like this, quote, the right of the law-abiding citizen to possess a handgun in his home and perhaps elsewhere shall be defined in future judicial opinions. That's the sum and substance of what I give you the message. I thank you for everything that's happened today, and I have to add one thought that occurred to me when Andy was reading about the agenda of debates that are going to be considered pro and con, and I would suggest to you on one of those debates, debate the pros and cons of the death penalty.